As we approach these cases, I never want us to lose sight of one important fact. Criminal homicide cases here are tragic, and some may even be difficult for you to read because of the suffering that takes place in them, the lives that are lost, and all the families devastated from it. I know because they impact me as well. We're a far cry from the dumb burglar stories or the petty thefts that we've discussed. Let's start with Bingham versus State from Washington State. This is a truly tragic case. Intersection of two people in a random set of circumstances that put them together and resulted in the purposeful killing of one of them. It looks like defendant and the victim met on a bus. They interacted with some people during the day, and then he led her off down a fairly isolated road. Later, she was found raped and strangled. No matter the criminal homicide charge and whether the conviction is for murder 1 or murder 2, the actus reus is the same. We're going to start our analysis with homicide, which is the killing of a human being by another. Here we have a homicide. We know that Bingham was the actor who killed Miss Cook. She didn't die by suicide. She didn't die by natural causes. She died at the hands of another. His actus reus is a voluntary affirmative act of strangling her. He took her life by strangling her to death. Now the question is, what was his mental state when he did this act? We ask this question because that will determine which criminal homicide he should be convicted of. On that note, please check out the criminal homicide charges he faced. It's incumbent on the prosecution, and in some states the courts, to present all the possible kinds of criminal homicide charges that fit the facts. Remember, there's only one bite at the apple for the prosecution. Whatever is not presented is waived under double jeopardy. So it's not uncommon to see several different charges go to the jury. Each would be backed by a different narrative of what happened or what the defendant was thinking at the time. Ultimately, though, defendant's only going to be convicted of one criminal homicide, but the jury will have received various options. That's what we see in Bingham. For our inquiry, when we're dealing with purposeful killings, that's intentional killings, I want to start the analysis with murder 2. Once we've determined that there's evidence of an intent to kill, then we can consider whether we elevate it to murder 1. We know that murder 2 requires the mens rea of malice, and it requires one of 4 states of mind that must be present: intent to kill, intent to commit serious bodily harm, depraved heart murder, or felony murder rule. Here, the prosecution is clearly going to argue defendant intended to kill Miss Cook. How do we know that was his intent? It's the way of killing her that speaks to that. He strangled her until she was dead. Had he released his hold, she would have regained consciousness. Why did he do it? The prosecution's theory is that he wanted to have sex with her, either consensually or forcibly, and when she resisted him, he killed her. So it looks like, at a minimum, we have a claim of murder in the 2nd degree. Homicide with malice, evidenced by the intent to kill. But the prosecution is seeking a higher conviction than murder in the 2nd degree. Prosecution was seeking to elevate it to murder in the 1st degree because it believed defendant didn't just intend to kill. He had an added mental state of premeditation, of reflecting on that intent to kill. To answer the question of whether we have premeditation, we first need to determine the definition of premeditation we're going to use. The court offers a couple of excellent definitions of murder 1 premeditation. For our purposes, let's use the one from the jury instruction. So, our working definition is going to be: premeditation is the deliberate formation of and reflection on the intent to kill, or the intent to take human life. Can we prove beyond a reasonable doubt that in addition to demonstrating an intent to kill, Bingham premeditated on that intent to kill when he strangled Miss Cook? The majority in dissent have very different legal views of this event. Notice, they're not quarreling over the actual facts. They are disputing the legal interpretation of these facts. Manual strangulation takes 3 to 5 minutes of continuous pressure to complete. Were you surprised by that length of time? I was. In the movies, it always happens in about 7 seconds. So what's the state's argument here? The prosecution argues, and the dissent agrees, that defendant took Miss Cook down an isolated road, that when she refused to have sex with him, he kept choking her for 3 to 5 minutes to kill her. Since it takes 3 to 5 minutes to complete the act of killing her by choking her, by definition, defendant must have been thinking in his mind, going over in his mind, reflecting on killing Miss Cook. The majority saw it very differently. The majority opinion comes out with an important principle. It states that the opportunity to reflect on killing isn't sufficient. To prove the added mens rea of premeditation, the state's got to prove that defendant actually reflected on the intent to kill, actually premeditated. Not just that he had time to premeditate, not just that he had the opportunity to premeditate. Otherwise, without the aggravating mental state of premeditation, the homicide is back to murder too, using the theory of intent to kill. As of now, the court says the prosecution only has proven that there's time to reflect, that the state didn't prove that he did reflect on that intent to kill. Look at how strongly the court feels about this premise. You hardly ever see this. At the end of the majority opinion, the court offers a clear blanket statement that manual strangulation alone is never sufficient to prove premeditation. Going to have to show other facts to corroborate that. What sort of facts? The case of State versus Harris, cited by the majority, offers the sort of circumstantial facts it's looking for to demonstrate premeditation, and it includes much more than just choking. In Harris, the victim had been severely beaten, vacuum cleaner cords were tied around her neck, then she was choked, then when she was unconscious, defendant found a rock and delivered savage blows to her head. Court says that demonstrates not only the time to reflect, but obviously there's evidence that he kept thinking about killing her. That's what we're looking for in premeditation, reflecting on killing her. There's one other policy point that the court makes. It concerns the proper role of the court in cases like this. Although the court decides the law and the jury decides the facts, the court says it can't allow a jury to be impassioned primarily by brutal facts. I want to repeat what the court says here. The facts of a savage murder generate a powerful drive, almost a juggernaut, for jurors and indeed for judges to crush the crime with the utmost condemnation available, to seize whatever words or terms reflect maximum denunciation, to cry out for murder in the first degree. But it's the task and conscience of a judge to transcend emotional momentum with reflective analysis. For this court, the savagery of this case shouldn't dictate the result. An appellate court, this court concludes, has an obligation to ensure that the verdict is fair and is based on the facts that were offered at trial. And the court doesn't believe that the prosecution proved beyond a reasonable doubt that the defendant premeditated the killing. To the majority, these facts support another equally plausible view. Did you spot it? It's that all the planning you identified, taking her down a deserted path, isolating her, was just as much about wanting to have sex with her or rape her as it was about planning to kill her. Let's check out the dissent. The dissent can't let go of this 3 to 5 minutes. It's critical to its analysis. Indeed, where did you learn about the medical impact of strangling? Under Drafting 101, that we often talk about, you learned about it from the dissent. The dissent wanted you to hear the medical facts. As I said, this isn't like the movies where someone strangles someone to death in 7 seconds. It takes a long time to choke someone to death. And if the assailant releases the force from the neck, the victim is roused from unconsciousness. 3 to 5 minutes. The dissent uses this to hold on to its view that the jury's determination on whether the facts support premeditation should be honored. This is a striking difference between the majority and dissent's view of the role of the jury and the role of the courts. The dissent says the court shouldn't take away a verdict that can be reasonably found. And the dissent says there's good reason to have upheld the jury verdict. The dissent believes that this case demonstrates premeditation. There's more than just time to reflect. Defendant did reflect. Continuous pressure demonstrates he was reflecting on killing her, at least while he was strangling her. It doesn't require that reflection go before the entire act begins, but the dissent says it could occur at any point during that time. That was just a few seconds on screen. Did it feel like a long time to you? It felt like a long time to me. Can you imagine what 3 to 5 minutes feels like? What else could the defendant have been thinking about except the constant reflection on his killing her? The dissent raises several facts which it believes demonstrates premeditation. Let's look at them. Bingham took her to a secluded place. He raped her. He had time to desist while he was strangling her. For the dissent, this shows premeditation in killing her. To the dissent, you could find premeditation either as he took her down that road, thinking he's going to kill her, or while he's strangling her. For the dissent, either of those places is an appropriate place to consider premeditation. For the majority, the facts could have easily supported a plan to rape just as much as a plan to kill, and therefore prosecution didn't meet its burden of proof.